Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about assault weapon bans again because, as we know, we are really kind of getting to the precipice of a big moment, I believe, before the United States Supreme Court, where inevitably they're going to have to take one of these cases. Now, as we know, there are at least 4 petitions right now out of the state of Illinois and a separate petition out of the state of Maryland. And while many believe that the case in Maryland is most well suited to be accepted by the United States Supreme Court, we did this video recently where I was like, you know, the way the 7th Circuit in the state of Illinois has just been thumbing their nose at the United States Supreme Court, that maybe they might take one of the Illinois cases. Well, we're going to get into a case today. We've talked about this case before, but I think this makes some really good arguments as to why maybe this ought to be the case to be taken. So today, let's spend a few minutes and let's talk about the case to end assault weapon bans. Okay, here's the case we're talking about today. We're talking about the case of Harrel v. Raoul. Now, we have talked about Illinois case after Illinois case after Illinois case, and we've also talked about the Maryland case, and we've also talked about the California case, which is all sitting there, any one of which could theoretically be accepted by the United States Supreme Court. And candidly, as a lawful and responsible gun-owning American, you want this United States Supreme Court to accept review of that issue right now. Now, let's just get right into what the plaintiffs are saying here, because what this is this is a reply brief to the state of Illinois. So just so you understand procedurally what happened here, okay? Harrel, the petitioner, asks for review by the United States Supreme Court. The state of Illinois then replies with a memorandum saying, no, we should not be even hearing this. This thing needs to stay here in the 7th Circuit and percolate around for a while. That way we can deprive Illinois residents of their rights further. This now is the reply brief, again, from the petitioner saying, no, Supreme Court, this is why you should accept review. And it outlines the issues like this. The 7th Circuit's decision conflicts with Bruen and Heller. Respondents attempt to square the 7th Circuit's opinion with this court's decision in Bruen and Heller, but it is an impossible task. Beginning at the first stage of the analysis under Bruen, Bevis is holding that the plain text of the Second Amendment requires both a showing that an arm is in common use for lawful purposes and is not the type that is exclusively or predominantly useful in military service. And remember, when they're referring to Bevis case, what they're talking about is Bevis versus City of Naperville, yet another challenge to this exact same regulatory scheme in the state of Illinois. And as the plaintiffs point out here, Bevis was simply wrong to treat common use as relevant to the text at all. As petitioners have explained, the common use test is relevant only at the historical tradition part of the Bruen analysis. And this is a really important distinction, because what we're seeing in these courts that are hell-bent on upholding civilian disarmament legislation is they're taking the common use test and they're incorporating that into the very initial inquiry under Bruen, which is, does the text of the Second Amendment even cover this activity? Now, there should be a presumed inference that it does, but the courts now have taken the common use part, put it into the beginning analysis so that they don't have to reach the second part. But as the plaintiffs very wisely point out here, the in common use is how we begin to define whether or not there is a historical analog that could possibly justify the restriction. The court should grant certiorari to make clear that history permits only dangerous and unusual weapons to be banned. The oppositions demonstrate the need for certiorari to settle this issue. Because the text of the Second Amendment applies to any instrument that constitutes a bearable arm, and because any bearable arm that is in common use is necessarily not dangerous and unusual, and so cannot be banned under the only relevant historical tradition of firearm regulation, this case is a straightforward one. The banned firearms and magazines are beyond doubt bearable arms that are in common use, so no new textual or historical work needs to be done to resolve this case in their favor. And again, if we really want to see just how many of these magazines are in common use and therefore how not unusual they are, well, one only needs to take a look at this report right here from the NSSF, which we covered on this video right here. And listen, it is important And I think that this is going to be a golden opportunity for the United States Supreme Court to once and all define what does the common use test truly mean. As the plaintiffs point out here, in defending the opinion below, respondents' oppositions misconstrue the dangerous and unusual analysis in other ways that demonstrate the need for granting certiorari to clarify this issue. Both Illinois and Cook County's brief are replete with arguments seeking to demonstrate the alleged dangerous nature of the banned firearms and magazines, and assertions that the features that define so-called assault weapons are not truly necessary or helpful for self-defense. As to the former, such evidence is typical of attempts by litigants to sneak in evidence relevant to means and scrutiny under the guise of an analogical inquiry. The latter is similarly typical of attempts by litigants to substitute the judgment of the judiciary for the American people, though this court made it clear in Heller that it is the choices of the American people that are decisive when evaluating whether a type of arm is protected by the Second Amendment. Whatever the reason, the American people choose a particular type of arm for lawful use. Now, as you recall, what the state of Illinois was arguing is, hey, listen, these cases haven't even reached finality here. There is still a record to be developed, and candidly, the United States Supreme Court should not be accepting a case that's still in what they like to call the interlocutory phase. But as the plaintiffs point out here, one, where the hell do you think this is going? And number two, this is already such a huge mess that the United States Supreme Court probably should step in right now. The issue is fully developed, and the decision below is representative of a growing body of decisions that conflict with this court's precedent. Respondents charge petitioners with seeking to short-circuit the ordinary percolation process because there is currently no circuit split on this issue. That hardly helps respondents' cause where there is not a new issue, but rather the reemergence following Bruen of an old misinterpretation of Heller, and there is currently a uniformity of opinion among the circuit courts in flat violation of this court's binding case law. And again, in furtherance of the argument that, hey, no, United States Supreme Court, you can take this case right now, plaintiffs wisely point out these issues can be resolved in an interlocutory posture. Respondents argue that this case is also premature for certiorari because it comes before the court in an interlocutory posture. But where there is some important and clear-cut issue of law that is fundamental to the further conduct of the case, and that would otherwise qualify as a basis for certiorari, the case may be reviewed despite its interlocutory status. And then finally, as we know, the Bianchi v. Brown case that's coming out of Maryland is really ripe for the taking right now. It is ready to go. And that's why right now the smart money is on. That is the assault weapon ban case that will be actually accepted. But the plaintiffs here actually point out there's another vehicle by which the Supreme Court can deal with a multitude of these issues. In any event, if the court prefers a vehicle on appeal from a final judgment, it should grant and decide Bianchi v. Brown and grant and hold these cases pending decision there, which would be you basically would grant review, hang on to it, wait until you issue your ruling in Bianchi, and then vacate the rulings of the other courts, remand them down for further findings consistent with Bianchi. We thought that would work with Duncan v. Bonta and Miller v. Bonta, but here we sit today. The case we're talking about today is Harrel v. Raoul. We will link up the brief down below so that you guys can geek out on it for yourself. Listen, if you got any ideas for videos that we should be doing here at Washington Gun Law, click on that link right there. Some of the best videos we ever did weren't really our ideas to begin with. If you got any other questions about this issue or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.